Hi, everyone. Welcome to the sixth episode of The Conflict Counselor. I'm your host, Chris Capocia. I hope you're getting some value from the podcast. It's been a real joy for me to be with you. As I mentioned in our introductory episode, I am the volunteer attorney mediator at the 47th District Court in Michigan. In mediation, I assist the litigants in negotiating a settlement of their dispute so they determine the outcome, as opposed to the judge deciding the outcome for them. From time to time on the Conflict Counselor, we'll take a deep dive into a real case from my docket that I think is especially thought-provoking about the law and our shared values. One such case is the subject of today's episode. I call it the case of the faulty timing chain or not. You probably know that the person who files a lawsuit is called the plaintiff. In this case, a young woman. I'll quote her complaint word for word. Quote, sent vehicle for repair and paid for repair in full. Work was not completed as specified. Car issue continued to recur. Negligence and malpractice. Request for refund or compensation. Violation of consumer protection laws. End quote. The plaintiff sought to recover damages of $7,000 plus court costs from the defendant auto repair shop. Her car was an Audi sedan with 100,000 plus miles on it. She further explained that after it repeatedly stalled, it was towed to the auto repair shop where a timing chain issue was diagnosed. Now, for those of us who are not mechanics, the timing chain is critical to the proper functioning of the engine valves. The plaintiff said that the auto repair shop supposedly fixed the faulty timing chain for $1,850. She paid in full and drove away. Within 2 days, the plaintiff said, the car stalled again, so she called the shop about what to do. The mechanic suggested other possible causes for the stalling and advised her to bring the car back to the shop for further testing. This the plaintiff refused to do, having paid the defendant for a repair that did not fix the problem. Instead, she took the car to another facility that repaired a different component to finally fix the stalling problem at an additional cost of $3,000. The plaintiff sued the auto repair shop to recover the cost of both repairs, lost wages, Uber and towing fees, court costs, and emotional distress, totaling $7,000, the maximum recovery in Michigan Small Claims Court. After the plaintiff stated her case, I invited the defendant auto repair shop owner to respond. He said they did the standard diagnostic tests on the vehicle, which were submitted as evidence. The tests only indicated a timing chain malfunction that was duly repaired. He stated that the plaintiff declined further testing and never proposed a resolution of her complaint before bringing the lawsuit. He went on to say that high mileage, older vehicles pose diagnostic and repair challenges due to multiple worn components. Okay, having heard from both parties, it was now time to do a reality check of their claims and defenses. This is when I tell the parties how the judge might look at the case. The purpose is to give a realistic assessment of the pros and cons of their positions, so they might be more open to a compromise settlement. First, I reminded the plaintiff that the defendant's legal obligation was to make a reasonable effort to properly diagnose and repair the problem, which, frankly, the evidence suggests it did. Likewise, I reminded the shop owner that the continued stalling might suggest that the diagnostic testing was incomplete and the shop was therefore negligent. The judge would consider these issues and others, like the miles on the car, the additional expenses incurred by the plaintiff, etc. Okay, the parties have now heard from each other and me. I ask if they might consider a monetary settlement at mediation as opposed to an uncertain outcome with the judge. Surprisingly, and without much hesitation, the defendant shop owner offered the plaintiff a full refund of $1,850. Now, the plaintiff was accompanied by her fiancé at mediation. They chatted a bit. He thought this was a good offer. However, the plaintiff was visibly reliving the stress of the whole experience, being stalled in busy traffic, the expense of 2 repairs, time off work, court costs, etc. She just wasn't satisfied. She wanted more money. Again, to my surprise, the defendant offered an additional $650 for a total of $2,500 in return for dismissal of the case. Also, the defendant owner apologized for the mishap, stating that he was thinking of his own daughters and would not have wanted them stranded in traffic in a disabled vehicle. He said that he wanted to do right by God and the plaintiff. Wow. It's not often that we encounter such genuine contrition at mediation. I suggested to the plaintiff that she give serious consideration to this offer and to the risks of allowing the judge to decide the case. So, after a brief chat with her fiancé, the plaintiff accepted the revised offer and dismissed her case against the defendant. I believe she was ultimately moved to accept the offer by the sincerity of the defendant's apology. And here's a good life lesson, by the way. Never underestimate the value of an apology, especially if you're on the wrong side of a lawsuit. So, the shop owner immediately presented a check for $2,500 to the plaintiff, and the case was dismissed without prejudice. Okay, time for a little sidebar where we explain some legal terminology. What do we mean by the term without prejudice? When a case is dismissed without prejudice, it can be reopened if the settlement fails. For example, here, if the defendant's check was returned unpaid, the plaintiff could have reopened the case. Alternatively, when a case is dismissed with prejudice, it cannot be reopened. Here, if the plaintiff had been paid in cash, the case would have been dismissed with prejudice since she received her settlement immediately. Well, let's talk about what happened here. It's not often that an auto repair facility will offer a full refund and then some. The plaintiff wisely accepted the offer, even though it was substantially less than her claim of $7,000. In my opinion, as a lawyer for 30 plus years now, the judge would likely have dismissed her case. The preponderance of the evidence showed that the auto repair shop fulfilled its contractual obligations to diagnose and repair the vehicle. Okay, time for another little sidebar. What do we mean by preponderance of the evidence? Very simply, the proofs and the law supported the defendant auto repair shop more than the plaintiff customer. The preponderance of the evidence is also known as the featherweight test because it may only take a little evidence, a feather's weight, to tip the scale in favor of one party or the other. Here, the testing indicated that a faulty timing chain was the problem, nothing more. In addition, the car was an old model with high mileage, and the repair shop was not given an opportunity to resolve the complaint before the lawsuit was filed. Now, having said this, we can certainly sympathize with the plaintiff. We may have experienced a similar situation. She was a young woman who was again stranded in her vehicle, distraught and fearful for her safety. After paying the defendant $1,850 for a repair that didn't work, she honestly believed that the shop was negligent in the transaction. In the end, I actually think the settlement was a win-win for the parties, both of them. The plaintiff was reimbursed every dollar she paid to the defendant, plus an additional $650. A clear victory because the facts and the law would not have persuaded the judge to rule in her favor. As I said, I think the defendant repair shop fulfilled its legal obligation in this transaction. So, you might wonder, how was the settlement a win for the defendant, who paid a total of $2,500 to the plaintiff? Had the case been dismissed by the judge, it would have been a hollow victory for the defendant repair shop. The owner clearly felt some responsibility for the plaintiff's ordeal. So, to assuage his conscience, to do right by the plaintiff and God, as he put it, he went beyond what the law required. For his emotional well-being, he needed to make that payment to the plaintiff. So, did justice prevail? I don't know. But peace prevailed. Of that, I am certain. What do you think? Thanks for listening to the Conflict Counselor. In the next episode, we'll talk about the most important thing not to do if you are sued in small claims court. Don't miss it.